Welcome, everybody. Last panel of today. Not too many in the audience, which is more than understandable. It's Friday. So I would like to thank you for sticking to the conference and coming to this panel, which is entitled Protecting the Digital Rights of Asylum Seekers and Refugees. I am Francesca Palmiotto, and I'm assistant professor of law at IE University in Madrid. And I have been tasked with a very challenging role of actually being the moderator and the speaker at the same time. So I will try to find a way to make sure that you understand when I'm moderating versus when I'm speaking. So today in our panel, we're going to discuss the role of data protection law in safeguarding asylum seekers and migrants' rights. The aim of this panel is to foster a collaborative dialogue between academia, civil society organizations, and data protection authorities to close gaps, or perhaps less ambitiously, at least highlight gaps that we have seen in our work between law and practice. So let me introduce our speakers. First of all, Daria Otskul, who is assistant professor of sociology at the University of Warwick and co-investigator of the AFAR project, which has organized this panel. Next, we have Eleftherios Kiliodakis, who is a data protection lawyer and executive director of Homo Digitalis. And finally, Joanna Farking, a legal officer in the Supervision and Enforcement Unit of the European Data Protection Supervisor. We envision this panel to be highly dynamic, so we will have first of all, I will give the floor to the speakers, also to me, this time in the role of speaker first, for a very short presentation about our work. But the main part of the panel will be actually a discussion among us, following three overarching themes that I will introduce later. And then I will open the floor for Q&A discussion with you. Okay, so without further ado, let me start introducing very briefly the AFAR project. So actually, prior to joining IE University, I was a postdoctoral researcher at the AFAR project. AFAR, as you can see, stands for Algorithmic Fairness for Asylum Seekers and Refugees. It's a project that is hosted at the Hertie School in Berlin at the Center for Fundamental Rights and is funded by Volkswagen Foundation. So what we look at in AFAR, we aim to explore how the use of new technologies, how new technologies are used in migration and asylum governance and their implication for fairness. Fairness is the core concept of our project, which we investigate as a multidimensional concept. First of all, we look at individual fairness, then distributive fairness, and finally, we also look from a more empirical perspective, perception of fairness. We are a very multidisciplinary team located in different beautiful cities in Europe. So from UCD Hertie School team led by Professor Catherine Costello, who is the principal investigator of the project, Copenhagen University, Oxford, Warwick, also EUI, and finally also Zagreb University. These are some of our research outputs, which we will be introducing today. So most of the discussion by me and Daria, we are together in this project. We draw on a couple of papers that we published, and particular one that we have co-authored. So these are some of the main research outputs. Daria will talk in a second about our co-author paper, which is really the main core discussion of today on litigation and rights of asylum seekers and refugees when new technologies are used. But before that, this is just wanted to draw your attention to a couple of research findings. This is one of my paper, which was published last year, entitled "When is a Decision Automated?" So this paper basically largely draws on the empirical mapping, which Daria has done, a very important report where she has basically mapped out all the current practices, how new technologies are used in the field of migration and asylum governance in Europe. And from this empirical data, my, let's say, curiosity as a researcher was to reread Article 22 of the GDPR, so the provision of automated decision-making, but this time not just from a legal, theoretical, and doctrinal perspective, but by taking into account how new technologies are actually used in practice. And what I found throughout my analysis is that actually automated decision-making in practice is pretty different, and it's not so binary as Article 22 GDPR. So it's not just something solely automated decision versus non-solely automated decision. Actually, what we see in practice is that these tools are used for triaging applications. We have also what I call automated evidence. This is mainly and largely used of decision-making tools, so to provide evidence that is then used by public authorities to take eventually decisions. And finally, what I call automated suspicions, so the use of automated system to actually create a suspicion about an applicant, which then justifies certain follow-up actions by public authorities. So what we see from the law and practice is that the provision of solely automated decision-making and related rights is hardly actually enforced in the practice. We have some problems in understanding concretely when a decision can be qualified as Article 22 GDPR. And in the cases where it's very clear that it does not qualify under Article 22 GDPR, there are still many problems because, as I show, these are automated systems that still impact fundamental rights, and therefore we need to raise awareness about how individuals that are impacted by these type of technologies can actually fully exercise their rights and obtain transparency in that sense. Another important research output of our project is the tech litigation database. So this is a freely accessible database where we collate all type of decisions from judicial authorities and non-judicial authorities, in particular data protection authorities worldwide, on automated decision-making systems broadly intended. So we have collected all of this case law and make it available on the website. You can use any type of search terms to find what courts or data protection authorities have ruled on this type of systems, not just in the field of migration and asylum, but in many areas of public law. So I invite you to check it up as an important tool, not only for research, but also for legal practice. So with this, I will give the floor to Daria.
Microphones there. Okay, do these microphones work the same way? Okay, maybe I'll use these ones then. Okay, excellent. So hello, everyone, and many thanks to Francesca for introducing our project. So I'm one of the PIs in this project at the University of Warwick. And I will tell, in this talk, I will tell a bit more about one of the studies that we conducted with Francesca, specifically about litigation and how litigation, to what extent litigation is possible, but also to what extent litigants face particular obstacles. So just to add to this tech litigation, you can check the website and see what we have covered so far. If you come across with any particular case law, you can also, there's a form that you can fill in, and you can also let us know if you come across with any cases in the future, so we can add that as well for future case law as well. So I think it's a really good resource. So basically, when we were doing this research and when we were gathering all the case law and looking at cases that were contesting automated systems in migration and asylum, but also more broadly, we realized that most of the cases, especially in the migration and asylum context, were being taken not by data subjects themselves, so not by migrants or asylum seekers and refugees, but most of them were being taken by civil society organizations. This is perhaps not too surprising, and we can discuss the reasons for that in the panel more, but we were really interested why that was the case, what were kind of the obstacles were for litigation, and also how civil society organizations were going about it, so what kind of methods they were using. We realized, for example, in some cases they weren't going to courts, but they were going to data protection authorities, or sometimes they were using other methods. So we really tried to understand what were the reasons for them for doing so, and kind of really try to go a bit more in depth with that. There were kind of around 10 cases or so that we identified, but at the end we decided to focus on 5 of them, so for a more kind of in-depth analysis, and these are mostly the uses of mobile phone data analysis that you may perhaps know. So this is either used in the asylum procedure in Germany, for example, or it may also be used in the border zones when migrants are intercepted by the authorities. Another practice that we looked at is the electronic monitoring. So these GPS ankle tags that are put on migrants, basically ankles, to follow where they are, whether they stay in the location that they're supposed to stay. And then also other cases in Greece, surveillance systems in reception centers and social media monitoring systems. So all of these cases were being led by civil society organizations, and we will discuss a bit more. In some of them, there were also coalitions behind those actors as well. But basically in the research and in the article that I will show you later on, we looked at each of these cases more in detail. And what we have, and we interviewed also contestants and people who were trying to bring these cases either to court or to other avenues. And what we found, quite quickly, was that they were, when contestants were trying to contest the new technologies in this field, they were facing 3 main obstacles. And the main obstacle that they faced was a difficulty in accessing information. And this is really crucial, especially in the migration asylum context, but in also other contexts, that it's really hard to know whether there is any automated system, whether there's any kind of technology that's being used, if it's not publicly available, if it's being used behind the kind of walls, you don't know whether it exists, you don't know whether there's any kind of automation behind the decision. Sometimes you may know that there is a technology, like for example, electronic monitoring, you know that it exists and some people are subjected to it, but then you don't know how it works, you don't know what kind of detail, what kind of details the authorities are collecting, and then what happens, whether or not it's accurate or inaccurate, and so on. So the accessing information, really trying to understand how the system works, has been the main obstacle that civil society organizations have faced. And in one of the interviews that we did with Privacy International, they were saying that this is really the main hurdle. Secondly, the second obstacle that we found was that sometimes civil society organizations may lack the technical knowledge about these systems. So even though they can understand, they can find that there's a system behind it, they may not know exactly how it works, what kind of technical limitations can be associated with that technology itself, so kind of what can go wrong, technically speaking. And the third and related obstacle is obviously without having this comprehensive knowledge about the system in place, they may not be able to go to courts because they don't have evidence, or they may even not go to DPAs, again, without sufficient information. So despite all these kind of barriers, someone was asking me, is it all really kind of pessimistic? And I want to be hopeful here, because despite all these barriers, a number of civil society organizations across Europe have been working really hard, really actively, trying to kind of overcome these obstacles. We found that they were really trying to mobilize, and we found that they were trying to mobilize in 3 main ways. So the first one is, in the face of accessing information, they were trying really hard to demand transparency. And one way they were doing that was they were either collaborating with migrants and their legal representatives to obtain data subject access requests. So for example, in the case of electronic monitoring in the UK, Privacy International worked with migrants and their representatives to convince them, well, to tell them to obtain the data subject access requests. And then once they got them, then they could understand how the technology was working. So for example, how often the GPS ankle tag, I mean electronic monitoring, how often, for example, they were gathering data, whether or not it was inaccurate at all. So they sat down, for example, with the migrants asking, is this true? Is this location true? Trying to find out whether the technology was in fact accurate and so on, and trying to find information to challenge the technology that way. Another way that we found that organizations often use is asking for data protection impact assessments, because that can give a lot of information about the technology in use. But however, of course, in practice, this can be quite difficult because of authorities, especially particularly in this context, often don't publish the DPIAs publicly. Or they may publish them, but they may release only very heavily redacted versions and so on, or they may completely ignore the requests. So it can be quite challenging, but it's another method that organizations have been using. And finally, we saw that most of the organizations and researchers as well were actively using FOI laws as well to have information about the systems in place. So they were asking for training materials, for example, user manuals to understand how the technology was working. They would ask for also data protection impact assessments. They would ask for source codes and contracts with the providers and so on. So it's just really trying to understand as much information as possible about the technology and the potential harms that they can cause. But again, we saw that in practice, again, the FOI method was also not very successful, not always successful, I should say. So authorities may reject or they may release, as I said, heavily redacted versions. They may completely ignore them, as we will hear in a few minutes, I think in Greece case. Or they may respond only after a long delay, and then that staff officer may already have left the office and so on. One particular challenge in this field, I mean, in the context of migration in particular, authorities can always, we found that they often reject requests based on national security, migration being a security issue, or public interest or commercial interests, because they often work with companies to produce these technologies. Another method that we found out, often in this field, organizations collaborated with other external actors. So let's say sometimes they would collaborate with technologists, or sometimes they would also collaborate with other organizations or academic researchers that have specific expertise in data protection law. With the technologists, I want to mention some, I mean, it all depends also on the capacity of the organization as well. So some organizations have in-house technologists, like Privacy International, for example, has their own in-house technologists that they can always ask them questions to see how this technology may be working and what kind of limitations there may be. And then other organizations that may not have that capacity may work with technologists specifically for a project. So that happened, for example, in Germany. GFF worked with a journalist who had a computer science background just to understand how mobile phone data extraction was working and what could be the limitations with that technology. Finally, I mean, only after all this collaboration and only after really trying to find all this information, which takes usually quite a long time, then the organizations decide whether they can go to court, whether they have sufficient evidence, whether there's legal opportunity structures for them to go to a court. Sometimes that may not be possible. And they may decide otherwise to go to a data protection authority. And we found that DPIAs really emerged as a really important actor here. And we also found that organizations resort to DPAs for two main reasons. So first, either the legal action in courts is not feasible, but also maybe it can be practically impossible. So for example, in the case of the Home Office in the UK, when the Privacy International was trying to challenge the use of electronic monitoring, and when they were trying to put in a judicial review, with migrants who were intercepted to this technology, the Home Office quickly decided to take the GPS ankle tag from the person, so they couldn't continue with that case anymore. So sometimes it's practically impossible, and then only then they decided to go to the DPA in the UK, which is the Information Commissioner's Office. So depending on what is feasible and not feasible, they may decide to take the case to the DPA. And then I guess we will see more in the with Eleftherios's talk, perhaps, that sometimes they can also decide that data protection issues that are that exist are too serious enough that really warrant a DPA investigation, and that's what happened in one of the cases. So really, I mean, just very briefly, I suppose, like, in this field, due to, I really want to be hopeful because it's, despite all the obstacles and barriers that exist, organizations really do work quite hard. It's not a really, organizations are watching and are trying to contest, but really the litigation phase is really quite difficult, and the pre-litigation phase itself takes a very long time, and it's quite resource intensive. So in the article, we go with each of these cases quite more in detail and show what kind of obstacles and barriers exist. And we really illustrate that as a kind of a wall that organizations have to climb to reach the litigation phase. So I'll leave it here. You can either just Google the name of the article or scan the codes and email me if you have any questions. Maybe. And next we will go, I suppose, with one of the more cases with more in detail, and Eleftherios will talk more about what they've done in Greece.
Thank you. Hope you can hear me now. Lovely. I will sit also here so that we can start the discussion afterwards. I was thinking if you're familiar with Greek mythology. Thank you. Any of you have heard about titans, about centaurs, about mythical beasts? One person, two persons, a lot of persons, perfect. Today we're going to speak about two mythical beasts, and their names is Centaur and Hyperion, but unfortunately it's not for... this one, perfect. Lovely. Unfortunately, it's not for something good. What is Centaur and Hyperion? In Greece, we have these close control access centers, and they are located in different islands. Let's say Lesbos, Samos, Chios, Kos, Limnos, islands that maybe are on your bucket list for this summer. It's quite impressive to see that Centaur and Hyperion are actually two surveillance systems. Centauros cost about 9.4 million euros, all funded by EU through the Resilience and Recovery Fund. And it is composed of a series of technologies like CCTV cameras, drones, and a thing they called AI behavioral analytics software. What does Centauros do? It monitors actually the perimeter and also the assembly areas within these close control access centers, which are also places for identification of people on the move, and it automatically signals alarms of unlawful behavior. So when we were firstly finding out about the system back in 2021, we were reading the official description of the Hellenic Ministry of Digital Governance. It was like a sci-fi scenario where, for example, the system, the software in the CCTV camera understands that there is something wrong going on. It sounds an automated alarm, and maybe drones are flying there to see for themselves if something wrong is going on. Quite far-fetched. Hyperion, on the other side, is actually an entry-exit system. So it is a security IC system also deployed in close control access centers. And the idea behind Hyperion is actually that you need a special ID card with some biographic information on you and a nice photo. And then you should use your fingerprint in a smart gate in order this fingerprint in the smart gate to recognize you, and you should enter the facilities. The special ID card also serves as a token to receive basic necessities. This was the idea. I don't know for sure if this is actually implemented in place, but you can also see how identification in such a form could be used in order to receive basic necessities like food or drugs and other type of medicine. And the bad thing with Hyperion, not that it was not bad enough, it was that it was declared confidential early on. So out of the 11.7 million euros, we don't know exactly where these money were allocated. We know that the funding was from the ISF, the Internal Security Fund at the very beginning, and then extra additional funding was, let's say, provided through the Recovery and Resilience funding, but we don't know anything else apart from the fact that by mistake they uploaded on our transparency portal a small contract of 20-something thousand euros, and one of the journalists who's also in the room, Apostolis Fotiadis, with his team, managed to figure it out at Balkan Insight and Bearn and Solomon, and they made an impressive story out of it. Now, here we have some photos so that you can put an idea on your mind on how these things work or look in practice. And these photos are from one of the reports of I Have Rights, an organization from the Border Violence Monitoring Network, with whom we are collaborating with. On the left side, you will be able to see some CCTV cameras, and on the right side, you will be able to see these smart gates. Now, I have here a timeline. I'm not going to go through all of this. I just put it in order so that you can have it in a nice chronological order. So we found out about it in 2021 through an official document of the Hellenic State. There, we started looking a little bit with EDRI, our network, European Digital Rights, about it, because we thought that, okay, we need to gather some evidence, we need maybe to facilitate discussions, we need to speak with policymakers, with experts in the field to understand that, okay, maybe we are a civil society organization, maybe we have a different understanding of how compliance should be conducted, maybe we are wrong, we need to ask more experts. In this context, we started mobilizing ourselves, and we also sent some FOIA requests to the Hellenic Ministry of Asylum and Migration, which were not responded, unfortunately. And through EDRI, a lot of discussions were taking place also in Brussels, so the LIBE Committee of the European Parliament started asking questions to the Hellenic Data Protection Authority. This was very good in our end, because taking on this, we will be able to speak to more civil society organizations in Greece. Actually, we were in contact with the Hellenic League for Human Rights, which is one of the most old and long-standing organizations in Greece, very well respected. HIAS Greece, who is based in Lesbos and have actual eyes and ears on the ground, and academic Niovi Vavula, who back then was working for the Queen Mary University, and now she's a professor at the University of Luxembourg. And all together, we decided to build a coalition and file a request for investigation to the Hellenic Data Protection Authority. Why is that? Because we were unable to find a data subject. As you know, data protection law is data subject oriented, so you need a data subject to mandate you to file a complaint. It was very hard for us to build the trust in such a very short period of time, so we decided to go with this request according to Article 58 GDPR. And we didn't know even if GDPR is applicable on the law enforcement directive, because in Greece, irregular migration is criminalized. So it was quite not super clear back then when GDPR stops and the law enforcement directive application comes into force. The Hellenic Data Protection Authority actually started investigating the case 1 month after our request. And we could see that this, let's say, wave of interest around the case was very helpful for this particular case in Greece. And a little bit later, also UN bodies like the UN High Commissioner for Refugees, the delegation in Greece asked also more questions. They sent an open letter to the Data Protection Authority. Investigative journalists also played a crucial role, because when you do something and you file a request, it is very important that people who have a lot of expertise in finding information to keep right about the case. So we had Solomon, we had Poulis and Seder, Lydia Emanuelidou, Apostolis Fotiadis, Stavros Malichoudis, a lot of journalists from also other media like Balkan Insight were writing about the case and were bringing a lot of important information. So 2 years after, in April 2024, the Hellenic Data Protection Authority decided to fine the Minister of Asylum and Migration. But it's important to highlight that they did it only for 2 reasons. They said that A, the Data Protection Authority said that A, the Minister of Asylum and Migration did not collaborate with us, so the ministry breached Article 31 of GDPR. They didn't provide documents, they didn't provide data processing agreements, they said that Hyperion is under a confidential contract, so you cannot see the contract, things like that. And the second reason is that they didn't conduct the data protection impact assessment on time. So they said more or less that you know something according to the data protection by design by default principle and to the data protection impact assessment obligation, you have to do it quite early on, let's say before the public procurement of the contract, because if you have already decided the technical and organization measures, the data processing activities, and you hire somebody to do the job, maybe it's quite late to do the data protection impact assessment after this. Just a preliminary one, it's important. So the Hellenic Ministry of Asylum and Migration did not have something handy, so they fund the ministry only for these two aspects. They didn't look into the practical aspects of the case, they didn't look into data transfers between the Hellenic Police and the Hellenic Ministry of Asylum and Migration. So this opened the way for more litigation. And in July, we saw that the Ministry of Asylum and Migration decided to file an annulment. They think that they have not done anything wrong, so they decided to appeal the case, and in September we have a hearing about that. Also, they published some privacy policy on their website about Kendavros and Hyperion, and we are analyzing them now with our good colleagues from the Border Violence Monitoring Network and I Have Rights, because we have run some testimonies with them, some questionnaires, and we see in practice how related, let's say, obligations are not respected. Next Thursday, we have also a new report together with them. Yes, here are some, let's say, ideas for further reading. Sorry for taking a little bit more. Here's Joanna, the floor is yours.
Thank you. Yes, I'll be a little bit briefer. I'm just going to give a quick introduction to the EDPS and mention some aspects of our work that are relevant to the context of this panel that could provide maybe some jumping off points for discussion later on. Okay, let me see. Right, so the EDPS is the Data Protection Supervisory Authority that is responsible for monitoring and ensuring compliance with data protection by the EU agencies, institutions, and bodies. So when it comes to protecting the digital rights of people on the move, the activities that fall primarily within the EDPS's mandate relate to supervising the processing by Justice and Home Affairs agencies, in particular Frontex. I can mention also the EU Asylum Agency, Europol, and so on. It also includes those parts of the large-scale information systems that are managed at EU level by EU agencies. So we're talking about the central systems of the Schengen Information System, the Visa Information System, Eurodac, and then also the forthcoming systems that are currently being implemented. So Entry-Exit System, ETIAS, which is the system that will mandate travellers to apply in advance for travel authorizations before travelling to the European Union, and also ECRIS TCN on criminal records. And in addition, we will supervise the technical management of the interoperability components that will create interlinkages between those systems and that will pool certain data from those systems. And I'll probably say a bit more about that later on. Now, it has been identified as a strategic priority for the EDPS to focus on digital rights of people on the move, which comes through a recognition of the particular risks and the particular high stakes of this processing, and an understanding as well that data protection functions here as a right that has strong interlinkages with other fundamental rights and can be instrumental to the access and exercise of other fundamental rights. So just to give one quick example of this supervision, the EDPS has intensified its supervision of Frontex in recent years, which is an agency that is fast becoming an information hub for migration and border management at EU level. And so, for example, we have audited Frontex's practices of collecting personal data in the context of joint operations. And perhaps I'll just mention one of our aspects or findings that related to that audit, building on what Francesca was talking about in terms of fairness, is that we looked at the impact of these collection practices on fairness as a data protection principle. And I think fairness and the principle of fair processing has a special relevance in the migration and asylum context, because it really concerns whether processing exceeds the reasonable expectation of data subjects. It comes into play when there are specific vulnerabilities of data subjects, where there are power asymmetries between data subjects and controllers, and whether the processing takes into account and provides safeguards for adverse impacts on fundamental rights. So our findings were published as part of our audit report, which is available online. So I won't say more about that. But another key area of our supervision concerning migrants and asylum seekers is in terms of supervising and monitoring the implementation of the Justice and Home Affairs interoperability framework that I mentioned earlier. Now, this framework presents several challenges from a data protection perspective, challenges which are linked to the large volumes of data that will be processed concerning non-EU nationals, the very complex data flows that this will involve across multiple authorities at both national and EU levels that will be accessing and further processing for this data for a variety of purposes. It will involve automated processing on a large scale, so cross-checking, also biometric verification, watch listing, and it will introduce algorithmic profiling under the new systems for travel authorizations and for issuing visas. And this is an area where it's not only novel in terms of the responsibilities are being put on an EU agency to implement this algorithmic profiling, the so-called screening rules, but for the EDPS as a supervisory authority, this represents a new area, let's say, of supervision that we are being called upon to perform. So the EDPS will be competent to supervise Frontex's implementation of those screening rules. And also the EDPS is a member of the Fundamental Rights Guidance Boards, which have been established to oversee both the operation of the screening rules in the context of the ETIAS system and in the context of the visa information system. So how these screening rules will work is that they will make use of historical data concerning, for example, immigration infractions, also incidences of security and criminal acts. Those risks will be linked with specific characteristics of non-EU nationals, and they will be used to draw up risk profiles, which will be used to score the risk levels posed by individual travelers. You move to my next slide. And so, although the specific risk indicators do not rely on protected characteristics, they nevertheless could use proxies which could lead to indirect discrimination. And so the EDPS, as part of the Fundamental Rights Guidance Board, has been very active in providing advice and guidance during this preparatory stage I should say that the screening rules under ETIAS will not come into effect until the entry into operation of that system, which is not foreseen for it's quite significantly delayed. So we're looking most likely at early 2027. But there is a great deal of preparation work that's ongoing, and to which the Guidance Board has been actively involved in terms of providing guidance to prevent discriminatory outcomes, but also to ensure judicial redress via the information that's provided to applicants. And I think this is an interesting example to mention because I think that it's indicative of the new roles that supervisory authorities are being called upon to play in the context of emerging technologies, the use of AI and algorithmic profiling, which is becoming increasingly common in this context.
Thank you so much to all of you. And I would like now to start the discussion with a question for all of you, which is if you can elaborate more. We have already seen from your presentation of your own work some overarching challenges that are peculiar that we need to take into account when we talk about data protection and enforcement of data protection in the case of this particular demographic of data subjects. So I would like to ask you a bit more to elaborate on what are the specific challenges in this field for putting ourselves in the perspective of asylum seekers, refugees, but more broadly migrants and people on the move in enforcing their digital rights, broadly speaking.
Yeah, I can start maybe and we go on. Yeah, I mean, this is a quite particularly challenging area for people on the move, of course, because so, I mean, I haven't mentioned, but there are so many different types of technologies that are being used in this field. And one of them, for example, automated processing of applications. And it's really hard for a migrant, or for a future migrant, to know whether their application is being subjected to any kind of automated systems, right? You just make a visa application and you just wait for the response and you don't know what's happening with that application. And if you get rejected, even if you know that there's an automated system behind it, if you get rejected, it's very hard for you to appeal that decision. So first of all, this is a population that's basically cannot appeal the decisions as easily as citizens. And even if they were on the territory, let's say, they could be still afraid of the authorities. I mean, imagine if you're a migrant, you're waiting, you're on a, you only have the right to stay for a year in the country. You wouldn't try to resist the authority or challenge an authority, knowing that your probably future application could be affected by it. Even if it weren't, you would be scared to kind of take an action against it. So it's a really, again, it's a population that's, again, in a vulnerable situation in that sense. And for asylum seekers in particular, again, they are particularly scared, and I've done some interviews with them, and none of them were interested in taking any action with the authorities, thinking that, of course, their application, fearing that their application could be impacted by their courage to resist the authority in that sense. With the mobile phone data screening, for example, many asylum seekers just comply with the authorities. They just give their mobile phone thinking that they have to do it. Again, they would find it really difficult to resist that because their application could be in danger and so on. So it's it's really important because this is a kind of a population that authorities can really test and start using these technologies, knowing that they won't really be able to say no to them and they will have to go with it. And in the meantime, they can keep developing these technologies and keeping, improving them as well. So it's a particularly, I'm a sociologist by training, so I don't call people vulnerable just per se, because I don't think anyone is vulnerable by themselves, but this is a particularly a population that have been made vulnerable due to the really little power that they have. So it's really important, I suppose. I don't know if you want to add.
To be honest, you said it all. Yes, we completely face the same issues. In terms of transparency, we see that in practice, people on the move are not well informed about the different data processing activities that take place. For example, there are not basic labels below the CCTV cameras, no privacy policies exist, they're not getting any information in language that they understand sometimes. Most of this information, in the better case scenario, will be Greek or English, not necessarily something that people on the move will necessarily understand. My English is broken and I was privileged enough to study them and whatever. So the second thing is also important to highlight the fact that we see that also it's hard to build trust. And because we are, for example, a digital rights organization, we're doing some work, we are not in the field, so it's quite hard to persuade an individual to go against the state, for example, especially in such a difficult position, in such a lack of a balanced relationship. These people want to start a new life. They're not interested in fighting strategic litigation cases on data protection law before Greek courts or European courts, and this is something that has to be respected. At the same time, we need to understand that maybe it's important to build coalitions, since we cannot actually get data subjects exercising their rights in practice. Maybe it's important for us as civil society actors, as academics, to build together synergies so that we can gather evidence, we can speak with clear arguments to the data protection authorities or before the courts. And with the data protection authorities, we see that it works. They started their own investigation, but it doesn't work all the time. We need investigative journalists to write about it, academics to provide credibility with their argumentation, and civil society organizations from social justice to work with digital rights communities so that we can exchange knowledge and expertise. We have other examples that they didn't work. The Kendros and the Perin is the good one. The others, unfortunately, are still pending.
Yeah, I mean, I can only echo the comments so far, and I think this is fairly familiar as a long-standing issue, certainly for DPAs when it comes to receiving complaints from this demographic. And for all of the reasons that have been mentioned, I think it's the specific situation of those data subjects, the familiarity with the language, with their rights, with the procedures. In certain cases, data subjects may not even be on the territory of the European Union when they wish to exercise those rights, which adds another hurdle. And this is certainly reflected in the very low number of complaints that data protection authorities receive, which concern processing in the migration and asylum context. I can certainly say, I mean, as EDPS, we are competent to handle complaints against Frontex, and to my knowledge, we have not received one admissible complaint to date. So it's indicative of the problem, I think. Now, in part, the onus is on controllers and authorities who are carrying out that processing to fulfill their transparency obligations, obligations for information provision in those contexts and at the border, which can be challenging in itself, but which I think evidence indicates is very often insufficient. So when Daria mentions, being asked to hand over telephone or such and such, I mean, in that situation, a person should be informed of exactly what is the purpose, what their rights are. If it's, I mean, based on consent, this is a very flimsy basis in order to extract data from a phone of a person in that situation. But there's also an onus, perhaps, more than perhaps, on supervisory authorities themselves, first to enforce those transparency and information obligations by controllers, but also to look at how they can conduct their own awareness-raising activities, and maybe to think about more innovative ways to raise awareness among these kind of groups which are not reached by traditional methods. Now, DPAs and the EDPB have published their own guidelines on how to exercise data subject rights vis-a-vis, for instance, certain EU agencies in justice and home affairs, so Europol, for example, and also vis-a-vis some of the large-scale IT systems, so the Schengen Information System, Eurodac. But as I said, it may require going beyond and looking at other ways of doing this, and perhaps working with intermediaries, as you mentioned, in order to leverage and have a kind of bridge that gap to this cohort of data subjects. Because I think this is a problem which is only going to be exacerbated by some of the regulatory changes and the technological changes that we've been talking about. I mean, when we think about the challenges of interoperability, for example, which will lead to an incredibly complex ecosystem of processing, how to meet the transparency obligations under the GDPR and the EU DPR for an individual who's having their data processed in that system is a huge challenge. It is extraordinarily complicated, and being able to provide information to one individual about the different systems that their data will interact with, the different authorities that could access that data, the different types of processing it may undergo. And that's without even considering how data subject rights will be exercised in this situation. There is no, there's not going to be a kind of central contact point for exercising data subject rights, or kind of a one-stop shop or centralized handling. So if somebody wants to know in what system is their data being processed and by who, they will have to apply to different authorities under different procedures in order to kind of piece together this information, which can take a great deal of time. And there is also a risk of individual requests being sort of ping-ponged between authorities. And this is something that, it's a risk that data protection authorities are aware of and are looking at and have flagged, but it's a huge challenge within the interoperability framework. And then if we look at the advent of algorithmic profiling and AI, then we have the additional issues of transparency, of accessing meaningful information. And for DPAs, it's a question of how to interpret and enforce obligations, for instance, under Article 22, the scope of application of Article 22 and the kind of recent court rulings on how to provide meaningful information in a clear and concise manner, which at the same time is sufficiently detailed in order to enable somebody to be able to contest a decision that's been taken via those means. So these are all like extremely complex challenges which kind of compound those barriers that we've already looked at.
I take this microphone you use that. Thank you so much. Perhaps following up on what has already emerged, my question would be how then we could foster, meaningful collaborations among different actors in protecting digital rights of asylum seekers and migrants. So perhaps first, Eleftherios, I picked up from what you were talking about before, and then.
Yes. Of course, it takes time. I remember it was 4 or 5 years ago when we were trying to speak with more social justice movements, and they could see data protection law not as a tool to fight back intrusive practices, but as a tool to normalize intrusive practices. So they were thinking that, okay, we have these new rules, but the only good thing about these new rules is that they enable the processing. But this is not true, and it takes time to persuade different groups of civil society actors to work together. So initiatives like the Justice, Equity and Technology Table of LSE, or the initiative by the EDRI network, the Decolonizing the Digital Rights Field, and now the Wave Liberation initiative, are helping social justice movements to work on projects with academics, with digital rights movements, because otherwise we will not meet to speak and to exchange ideas. And the same happens with investigative journalists. Different types of let's say, opportunities exist for collaboration and building trust. And I think that this is something that we need to do, because more and more complex cases evolve, and therefore more and more synergies are requested to bring knowledge and, yes, manpower together.
Well, maybe now I switched to speaker. No, yeah, I would also like to add to the previous conversation that we're having. That I'm a lawyer, and working on this field, we see it's the framework from a legal perspective extremely multi-layered. So of course, we're talking about GDPR, but you also have the Law Enforcement Directive. Now we also have the AI Act. So very different, sources of secondary legislation, and of course, primarily law as well. Of course, fundamental rights, Charter of Fundamental Rights, of course, the ECHR framework, etc. So it's extremely multi-layered. And in practice, if you look at it from, a very doctrinal perspective, you see that the toolkit is quite full of different tools that could be used if you think about, Article 22 and the right to explanation under Article 22 and related rights and transparency. Now we will have a new right to explanation under the AI Act, just to mention a few regarding automated decision-making more broadly. But then in practice, these particular data subjects are not put in the position to exercise these rights. And so in that sense, trying to also reply as an academic, from my perspective, I think is extremely important that also research is not dissociated from the reality. So when we talk about the law, it is extremely important to see how in practice these technologies are used, how in practice rights, and in particular right to privacy and data protection, is impacted. So in that sense, having this not only interdisciplinary, this interdisciplinary conversation was for me as an academic extremely important to contribute to this debate in that sense. So that would be for me, the added value from a researcher perspective, see how things really work in practice. Just to give you an example, perhaps in my paper on Article 22 GDPR on automated decision-making, I analyzed different systems. One core focus is on mobile phone data analysis that me and Daria have for a long time worked on and really tried to unpack and understand. What I was seeing is that, in practice, how it works is asylum seekers who apply for being recognized as refugees are de facto obliged to hand over their mobile phone when the authorities think that there are no other ways to identify the country of origin of the applicant. Okay, so this would be the first condition. There is a legal basis for this, and what happens is that the phone is connected basically to a system, to a software, and makes a readout of the data. And it creates a report. And the report is a statistical likelihood of the country of origin of the applicant from, for example, the calls that are made, geolocation captured in the phone, etc., etc. And it makes a statistical likelihood, okay? And that's the report. This report, so in theory, this is how I also categorize it, as a form of evidence. It's evidence that then is put in the file for the decision maker to take into account. But in practice, what we see again, so in theory, it would not qualify as solely automated decision because it's just one part, it's evidence. There is meaningful human oversight, there are other factors, etc., etc. But in practice, if the likelihood, the most highly likely country of origin is different from what the asylum seeker claims, this is actually decisive for rejecting their application. Why? Because the authority will say, will argue, you are not credible. You're lying, in other words. Because my report says you're not from the country where you claim to be from. So you are not credible. So it does have a decisive impact on the final decision. But of course, then, asylum seekers are not put in the position to have a meaningful explanation, to be put in a position to also contest that report, to provide themselves an explanation on what happened there, no, actually, I'm from this country. So in that sense, we see a huge gap between the law and the practice. And I think, it's very important to, bear this gap in mind. And as an academic, as a lawyer, is extremely, extremely important. So that would be my, my perspective in that sense.
Yeah, thank you. Maybe I can add, I'm not a lawyer, I should clarify. So I've been trained in political science and sociology, so I'm a social scientist by training. And I can add maybe that first of all, just to add to this practice, overall, all of the technologies that we've found out in this particular context are not used to help migrants or data subjects, but they are used really to basically reject their application or to interrogate them or to make it even more difficult to enter the territory. It's kind of used as a tool of interrogation. So we have to be careful that how technology is being used. It's not being used to confirm what the person is saying because they don't have anyway much power to resist it, but it's really used often to or they're designed to be able to use them to reject their case. So just to clarify on that. And secondly, you mentioned about the collaboration between academia and civil society. I think, I want to clarify, I think in academia, especially in social sciences, academia in general has been quite closed. So we have been kind of, talking to each other. Often we go to conferences, only academic conferences. We are only talking to people that work with the theories that we work with and so on. And I think academia is also slowly opening up, and that's really good, and we have to keep doing that. So for a long time, perhaps in the first 10 years of my research career, I would say I was more interested in the theories and how my data, my findings were kind of changing or contributing to theory. But more and more I realized, and I think a lot of more social scientists are realizing this, that the data that we are collecting from people, so the information and the interview data, for example, that we're collecting, can also be used as testimonies for organizations to challenge specific practices. So I think academia is also kind of going through a transformation and kind of going through a normative turn, especially in social sciences, I should say, which wasn't the case for a very long time. And we should be aware of that the data that we are collecting can also be useful in practice to challenge some technologies. But there are lots of ethical questions that I'm not going to go into detail, but the data that we are collecting is important, and we should be also a bit more aware of that, I guess, as social scientists. Shall I pass on?
Okay, there's lots of elements to pick up on from those comments. Maybe just to come back to Article 22, because I think it's a really interesting discussion, and it's something that we have also and will continue to be examining in the context of, for example, the ETIAS screening rules, this question of where does Article 22 kick in or not, or how, under which framework, and according to which legal obligations can information and should information be provided to individuals about the functioning of, for instance, an algorithm. I think, as more and more of these cases reach the courts, I think the kind of contours of that article are being fleshed out increasingly. And so for me, I think the Schufa ruling was quite informative, because there I felt the court sort of opened a bit the margin for the application of this article to also decisions which draw strongly on an output. And I think in the example that you gave, it could be argued that this would apply in that case. But then even where Article 22 doesn't apply, you have different legal obligations stemming from Article 47 of the Charter, where, again, there's an obligation to provide reasons for a decision, and the court extended those reasons to the predetermined criteria in algorithmic profiling in the Ligue des droits humains ruling of 2022, and then, of course, under the AI Act, Article 86. So, but what has been mentioned is that it's now dealing with the complexity of these overlapping regulatory frameworks. And that's where I think data subjects that we're talking about here are going to really struggle. And that's where I come back to your question about the importance of collaboration and cooperation between different stakeholders, because I think it's here where there could be a real benefit. When I think about DPAs and how they bridge the gap with these data subjects, and the role of, for example, NGOs, civil society organizations, migration lawyers, both to feed back information about the impacts of processing on the ground so that supervisory authorities can better target their supervision, but also maybe in order to kind of provide assistance and guidance that's filtered through those intermediaries, not to which is the best avenue for those individuals to take. And I also, in terms of kind of all capacity building and building the knowledge and expertise for all of those stakeholders, I mean, first and foremost, supervisory authorities themselves are having to very rapidly build capacity in order to kind of meet their new kind of roles and responsibilities, and not necessarily as market surveillance authorities under the AI Act, but just supervising the data protection compliance of AI systems and algorithmic profiling. This is extremely challenging. This requires a new kind of expertise, not just technical and statistical, but also in terms of really taking into account the wider fundamental rights impacts. And then I think it's interesting as well to look at how these new kind of regulatory governance frameworks are opening scope for cooperation. So if we think about Article 77 of the AI Act and the new roles that's accorded to fundamental rights bodies, and the obligations on market surveillance authorities to cooperate with those bodies and to notify them in case of serious incidents. If we think about the potential for cooperation in regulatory sandboxes, and I think this opens up new horizons, and whether by kind of formal or informal mechanisms, there's a lot of scope to do more there. And then if I think, just to finish, about other regulations which are coming into force, for instance, under the EU Pact on Migration and Asylum, for instance, under the screening regulation, where you'll have this kind of new fundamental rights monitoring bodies, and thinking about how they will integrate perhaps data protection in their work, and then feed back also the results of their monitoring to other stakeholders, which can be incredibly useful.
Thank you so much to all of you. So perhaps I would open the floor to the audience. If there is any question, curiosity, comments as well.
Thank you very much for your talk. It was really inspiring. I've been working on risk assessment technologies in criminal procedures for a long time. And after 4 years of work, seeing even in an area like criminal procedures where due process rights, it's so hard to outbalance them. So when it comes to immigrants, now I see that these are, again, getting introduced in this area. Can't we just ask ground zero question of why, to what purpose will this technology, like risk assessment, serve where already these people are considered as risks themselves, and instead of like dealing with if this criminal data is relevant, is it really relevant to severe crimes, why are we using this kind of data, and plus profiling it, can't we ask why? Why are we needing these tools? Thank you.
Shall we, yeah? I think just say this is a wonderful question, and
Just say just one sentence. I mean, most of the, especially in the risk assessment case, most of them are helping people whose mobility are seen as deserving and are like people who are seen as worthy of being mobile in the world. So people who have the higher either financial or social or digital capital in this today's world, that who are seen as well worthy of being mobile, they are being benefiting from these systems because their application can be easily accepted and they can easily travel, whereas people who are not in that category kind of are being weighted further. And yeah, that's just what these systems are doing, in my opinion.
Completely agree. Just to quickly add that these narratives are not standing alone creatures. They are somehow also complemented by the privatization, for example, of the border and migration field. And there are a lot of companies who have developed quite good lobby activities persuading that this is the way forward. If we want to tackle the administrative burden of people on the move coming towards Europe, the best thing is to assess the risk of these people coming and try to prohibit or limit their access. So there is a business model complementing and feeding into this narrative, which is quite a billionaire industry. And it's important to remember that a lot of safe-related defense-related, and security industry players are very good in providing very well-structured arguments to decision-making on that.
Yeah, maybe to add shortly, I guess to your question, I mean, when you have a new piece of legislation, it should undergo a test for lawfulness, necessity, and proportionality, right? So it's the task of the legislator to make a thorough assessment of whether that meets the necessity and proportionality threshold. I mean, and so in certain cases, this is done very thoroughly with a careful impact assessment, and in other cases, less so. I think once thinking, for instance, of the use of the screening rules, because you mentioned criminal and security data and linking this to travelers. I mean, there's a safeguard that says this should be implemented in a way that is targeted and proportionate. And I think it's the task, and it will be the task, of the Fundamental Rights Guidance Boards and over forms of oversight, like also the work of the EDPS to some extent, in order to scrutinize whether that is done in compliance with the regulation and to act accordingly.
If I may add just very briefly, actually, I work mainly on AI in criminal justice. Actually, that's really my field of expertise. And so what I see in both areas, it's an increasing use of technologies, but very uncritical. What we don't see yet is we don't have empirical evidence of whether these technologies actually are more effective than, let's say, analogical decision-making processes. We don't have data on that yet. But my concern is mainly the uncritical use of technologies and seeing technologies, especially AI, as a solution to problems that are more structured in that sense. So that's my main concern. Regarding, for example, mobile phone data, we talked about it, me and Daria, many times. The zero question is this system working? Can the system actually tell me the country of origin? And actually, the statistics we have from the authorities who uses it goes against this, says actually most of the time, in the majority of cases, this system provides inaccurate results, which we cannot use, are absolutely unusable. So in that sense, I think the zero question is, what is the scientific validity of the system? Can the system do what it claims to do? And this is a question that most of the time is not, in my opinion, sufficiently addressed and satisfied. So.
Thank you for the discussion. I thought it was very interesting. It's maybe not the most uplifting question, but I wanted to ask if you're noticing a difference in how your fields are approached with kind of the right-wing turn and the increased emphasis on competitiveness. In my experience, sometimes it does seem like, especially in the field of migration, the idea can be like, okay, just let us do this for now because we need to do this because we're developing an industry or whatever. Like, are you noticing a difference in how you're received or how you're listened to?
If we could take the other question together, maybe. There was... there was another question or a reaction? Okay. Easy one. Who would like to answer the? Okay. Okay, I will go and then you can.
For us as a civil society organization, a lot of times we are chasing, let's say, developments, and we have to react fast in related developments. But yes, to be honest, sometimes it's quite hard to persuade and to build coalitions in order to react more strategically in this type of issues, because also it's quite hard to persuade the public to care about related matters. A lot of people think that people on the move is something that is not related to their daily lives. Monitoring them, it's maybe also good for safety reasons. So it's quite hard to understand the fact that maybe legislative reform later on will allow for more intrusive measures to be taken for also citizens. And maybe the ECRIS TCN large-scale IT system is a nice example, because it speaks also about dual citizenship, if I'm not mistaken. And for example, somebody that has also an EU citizen but is coming from a third country national state is somehow in the system. So this could maybe open the way that, okay, you have already a large-scale IT system that at least sees dual citizenship, and one of that is the EU citizenship. But maybe I'm mistaken, because it is not my field of expertise. Yes, maybe somebody else wants to react.
Yeah, I mean, just maybe to add, maybe for the final words, at least from me, I think, I mean, overall, there's a lot of push for efficiency, and that, you know, we should have much quicker systems, and people, I mean, there's always this idea from governments, from authorities at least, saying that people cannot wait and they need these technologies. There's a, you know, for travel, for example, they want to travel, they want to get their decisions fast and so on. And often, first of all, we don't, like, there's always this discourse around efficiency, but most of that discourse is really about time for certain people. I mean, certain people's time is costly, right? Not everyone's time is that costly. Some people, actually waiting can help them more, but some people, it doesn't help. It's time is capital for them, and it's higher capital. And we don't talk about, when we talk about efficiency, actually about the financial costs of these technologies. They're often quite costly technologies. It's mostly from the, obviously, public taxpayers' money. We don't talk about that, whether we need them at all. We don't talk about it at all about the environmental costs of these technologies. So this whole discourse around that we have to be quick, and there's a, I mean, your question around competitiveness, that we have to be, you know, in this rush, in the whole AI rush era, that we have to find the right technologies as quickly as possible, really completely disregards all the other costs that we're paying and but we will have to be paying.
I think, yes, our time, I think, is over, right? So please join me in an applause for the speakers. Thank you so much. Again, really thank you, the audience, for being here, notwithstanding the late time. So thank you again, and thank you all, really, really, truly. Thank you.